Thank you very much, Hamilton, and I too would like to begin by acknowledging the Indigenous people of our land. It's appropriate that we do so in the context of a constitution which not only originally failed properly to acknowledge them, but imposed obligations and deprivations which were unique to them by reference to their race. I also would like to reflect upon those who have died and worked for our freedoms, which don't come without sacrifice. I'm very glad to be here in this facility. I thought I'd spoken in every facility in Australia, but this is something new, and it's a great facility, and one of the many things that you can be proud of in Adelaide and South Australia, places in Australia that are often, almost always, in advance of the rest of the country in thinking about ideas and how we can improve our country, which is why we are gathered here today. Because of my work in North Korea, I've lately been reflecting a lot on totalitarianism and what it is that leads countries into the abyss of totalitarianism. And I want to begin my talk tonight with a text, as a bishop would do, and I'm looking at Lynn Arnold. It's a text from Mein Kampf, which you don't normally quote in Australian political or legal contexts. National Socialism must claim the right to impose its principles on the whole German nation without regard to what were hitherto the confines of federal states. We must educate the German nation in our ideas and principles. As the churches do not feel themselves bound or limited by political confines, so the National Socialist idea cannot feel itself limited to the territories of the individual federal states that belong to the fatherland. The National Socialist doctrine is not the handmaid to political interests. It must determine the life of the whole people and shape that life anew. For this reason, we must imperatively demand the right to overstep boundaries that have been traced by a political development that we repudiate. And the repudiation of federalism is understandable if you are seeking to impose on a nation the stamp of a single direction and single ideas, and that is why federation is so important. It's a system of government which has a certain inefficiency, but also has a capacity, by dividing great power, to greater protect the liberty of the citizens. These are points that I made when I was a Justice of the High Court of Australia in the third of 4 cases that I'm going to refer to this afternoon. CEDA, the Committee for the Economic Development of Australia, is by its name a body which is principally concerned with economics. And this excellent publication, A Federation for the 21st Century, which has been prepared by CEDA and for which this is the Adelaide and South Australian launch, is substantially, though not entirely, addressed to economic issues. It can't be entirely addressed to them because it's many times been said that federalism is legalism. In a federal system, you have to have something that splits up power, and that something is usually a constitution, and the umpire is usually a court. And therefore law must be considered, and law is my discipline. I did undertake an economics degree, and to that extent I was a bit different from most lawyers, most of whom know very little about economics and don't really want to know a lot about economics, but my experience as a judge was substantially in the legal area. And as I ploughed my way in a dutiful fashion, like an ex-judge, through this publication, I thought to myself, what a good thing it would be if our processes in our courts were such that the Justices of the High Court of Australia had a book like this as a sort of background reading for a case concerning federal matters, because this analysis in the book raised many issues which I had not specifically focused my mind on, which were partly economic, but also, one might say, social and in a broad sense legal. And we haven't developed in Australia the method of assisting judges, as in the so-called Brandeis brief in the United States. Indeed, it's resisted by the judges lest their minds become contaminated by something other than that which has been written by judges or by Parliament. And therefore, they don't generally get this, and when they're reading, their private reading, they don't generally read it. And I think it would be very helpful if somehow we could change our procedures to permit that. Now, the book makes the point, Stephen Martin says it expressly, that our federation has worked well. And I suppose in comparison to many other states of the world, our system of government has worked pretty well over the century and a decade since the system was established. And therefore there would be a lot of people out there on the tram to the coast who would say, why do you want to fiddle with the Federation? Leave well alone. Brian de Garis is quoted in here as saying, it's very hard to excite the citizenry about matters of microeconomics. And that is a reality check that we have to remind ourselves at the beginning. Very hard to excite our fellow citizens about matters of microeconomics. The idea that we should freeze a percentage of the income of the federal government derived from taxation for roads, for health and for education, which is an idea that's basically floated in here, runs into a pretty fundamental constitutional principle that when you raise money from the taxpayers, it goes into one consolidated revenue and can only be voted by Parliament on the matters that Parliament approves. And therefore, the constitutional principle of appropriations would come in to challenge any notion that you can freeze a certain percentage of the revenue of government to a particular cause. I suppose you could do it by a constitutional amendment, but everyone in this room knows that over a period of 110 years, we've had 44 proposals for the amendment of our constitution, and on a recount, only 4 have succeeded, and most of those have been rather inconsequential matters. The record of referenda, too, has been that every time you come back to try it again for the second, third or fourth time, as was tried in the case of the conciliation and arbitration power, you go backwards, the vote gets smaller, and it's therefore a very cautioning thing that we have to keep in mind as we approach explicit change of the Constitution, and that's where the High Court comes in, because the High Court has the role of interpreting the Constitution, and interpretation includes seeing things in the Constitution that the founders didn't see and didn't expect, but which can be derived to meet the circumstances of the time. There's a wonderful first chapter in this book, if you haven't yet read it. It's by Professor John Cole, who I've just been told is an environmental scholar in law, but in fact this is sort of constitutional history. It goes back to the history of really what a close-run thing the federal arrangement was, how if it had been delayed probably just for another 10 years, almost certainly Western Australia and Queensland would not have voted to join the federal system, that the votes in many of the colonies were not a majority of the citizens of the colonies at the time they voted, and that in effect what was done was to stamp on the federation that ensued the colonial borders that were drawn up 150 years ago by the imperial authorities in Britain. It is significant, Professor Cole points out, that we've repeatedly rejected one of the important features of a federal system, namely to create new states, that we have repeatedly failed to correct what was an assumption that was mistaken in how things worked out, namely that the Senate would be the protector of the federal system and would protect the states, and that we have failed by constitutional change to alter the constitutional arrangements that have ended up very different to what was expected. So different that we are approaching a case where the federal parliament and government have the power and the money, and the states have diminishing power and such money as is granted out of generosity to the federal parliament, some of it most recently diverted to other recipients. Professor Grewal gives an excellent chapter on economic perspectives. Professor Nicholas Aroney gives a very good essay on diversity in other federations and the comparative lack of diversity in our federation, although he does say that diversity is increasing because of the multicultural nature of our society and the different multicultural communities in different parts of Australia. Jennifer Menzies has written on culture of Commonwealth and state relations, and I hope that she'll make some of the points there again this afternoon. A brilliant chapter by Anne Toomey on the legality of federal expenditures and so on. There are really excellent chapters, and it's a very good preparation for citizens, and I would add schools and school children around Australia, though they might need a little bit of simplification of the complex economics and law to understand all the points being made. Now, I said I was going to mention 4 cases, and I've only got limited time, and I don't want to revisit cases, although I will do so briefly, where I was in dissent in the High Court of Australia. But it is important to understand how we got to where we are in the financial arrangements that we have in the federal system. It certainly wasn't expected to be as it has worked out. And we got there, I think, very substantially because of the power of the will and the legal imagination, industry, energy and determination of Sir Isaac Isaacs. When the High Court was established, the original justices, the 3 of them, were unanimous that when you construed the federal power, you did so in a federal constitution. The Commonwealth's powers were to be understood in the context of the federal constitution because that is what they, as founders in the conventions, had intended. But Isaacs didn't believe in that. He was born upstairs in a shop which his parents owned in central Melbourne, and he was very grateful that they had been received into Australia as migrants and given protection coming from Jewish family in Poland. He was determined, and he sincerely believed that it was essential for Australia to establish an extremely strong central government. He thought only that would be the way to answer the perils that he saw every day he looked at a map. Essentially, he felt Australia had been established in the wrong place in the world, and the only way to defend its integrity and its culture and all of its people was to defend it with a very strong central government and parliament. And so the original doctrine that you read down powers so that they didn't needlessly diminish the power of state governments and parliaments was anathema to him, and he opposed it from the day he arrived in 1906. He kept opposing it until Sir Samuel Griffith left at the beginning of the second decade of Federation, and he persuaded Chief Justice Knox to agree with him. And there's a marvellous story which is told in the book, which is recounted by Sir Robert Menzies, of how he was arguing the case in the engineers case in 1920 before the High Court, and how he was there arguing that for a union, that the arbitration court could rope in a number of employers who included state employers, state government employers, and when he put his propositions, Mr. Justice Stark from the bench said, "What you are saying is nonsense." And Mr. Menzies said, "I am framing my submissions, Your Honour, in terms of what has been said by this court. If you, sir, will give me the opportunity to challenge those submissions, I will frame it in a different way." And so he was given that leave, and that led to challenging the doctrine of the immunities of state instrumentalities and the implied limitation on federal powers deriving from the fact that it was a federal constitution. And so he argued that way, and then in a decision which has been described by Professor Geoffrey Saw as the worst written decision in the history of the High Court of Australia, verbose, repetitive, rhetorical and unpersuasive, Justice Isaacs laid down the doctrine of the court, which has survived ever since. It's very important for non-lawyers to know that in doing so, he was basically following the way English courts construed statutes. They construed statutes very narrowly because they knew that the Parliament wasn't generally representative. The Commons of England wasn't fully representative until 1918, when women were allowed to vote, but that was the Privy Council's approach, very narrow verbal interpretation. And essentially, that is what the Privy Council had said in a decision in 1913 from the Canadian Constitution, and Isaacs said that that was the correct way to interpret the Australian Constitution. And that was stamped on the Australian Constitution in 1920 in the engineers case. Now, that case has resulted in the approach to the construction of federal legislation. It reached its apogee in 1942 in the midst of the war, in the first of the two uniform tax cases, when the federal parliament, in the midst of the conflict, said, "We impose income tax and we prohibit taxpayers paying state income tax." And the question was that competent to the federal parliament to do that, or would that be a step towards destroying the states? And the High Court in 1942 said that that was competent to the federal parliament. So that was the highest point that the engineers' doctrine ever reached. But there were plenty of other very high points, and one of them was reached during my service on the High Court of Australia in 2006 concerning the work choices case. Now, if only I had the time to tell you of the errors of the work choices case and the errors of construing the Constitution in the face of 4 referenda where the people had rejected the opportunity to amend Section 5135, the conciliation and arbitration power, and to allow that to be done under the corporation's power to the federal parliament. If only I had the time, but I don't. But in my reasons which are worth revisiting because they have no legal significance now. This is a battle that will never be revisited and it'll never be returned to. But in my reasons, I pointed out that there were good reasons of principle for supporting the federal system, and that this was effectively destroying the federal system because virtually everything that's important in our nation is now done by corporations, school corporations, hospital corporations, local authority corporations, and all the other corporations, and that this would be a way to ride roughshod over the divisions of the federal constitution. In my reasons, I pointed to the kind of consideration that was relevant to Hitler's proposition. Not that we've ever come close to a Hitlerian totalitarianism, but the notion that diversity and difference and division, and even at the cost of a little economic inefficiency, is a price worth paying for the purpose of our liberties, that the inefficiency of federal systems can be a protection for liberty. But in this excellent book, there is a whole chapter by Professor Anne Toomey on what now appears, since I left the High Court, to be something of a reversion to a reconsideration of the federal nature of the compact. There have been, in fact, 3 cases in the latest series. Case number 1 was a case called Pape against the Commonwealth, a case on taxation power. But cases number 2 and 3 were the Williams number 1 and Williams number 2 cases. These were the cases by Mr. Williams who challenged the chaplaincy scheme by which hundreds of millions of dollars were paid by the federal parliament to the states to support the chaplains in public schools, undermining thereby the state legislation of public schools being free, secular and compulsory. And Mr. Williams wanted to challenge them on that fundamental principle of religious separation of church and state. But his very clever lawyers said, let's try to challenge it on the fact that the federal government and parliament have no power to make such a subvention because there's no head of power that gives the federal parliament the power to support such a payment. And that is what the High Court essentially upheld. They rejected the Commonwealth's view that because it was a good idea, or because it was for a, in inverted commas, national purpose, which was approved by the federal parliament, that therefore it could be supported by the executive power and the federal money. And the High Court said you have to find and point to a head of federal power. So they are the 4 cases. The engineers case of 1920 that made the stamp. Then the uniform tax cases in the midst of war that got to the point that you could actually prohibit the payment of taxes, income tax to the states. Can't get higher than that. And then the decision of work choices that said you don't have to go through 5135 to conciliate and arbitrate, you can just do it under the corporation's power. Very high views of the power of the federal parliament. But now a certain pulling back from the implications of this. And so maybe somebody up there in the Sir Garfield Barwick's great concrete palace by the lake in Canberra is reading my dissenting opinion in the work choices case. I wish. So that's what I've come to tell you. You can't deal with this issue by pipe dreams. You can't deal with it by suggesting that we should give the federal parliament and people who currently have the power and the power over money simply an advisory function. Personally, and with all respect to the clever brains that put that forward in this document, I think that's a pipe dream. Those who have the power are not going to vote themselves out of that power, and I think we have to be very realistic. We also, who believe in a resuscitation of the federal arrangement in our constitution, have to be searching and reading very carefully the Pape and Williams cases for the hints that the High Court of Australia is now seeing where the reasoning of engineers and the uniform tax case and the work choices case lead us. The Prime Minister has announced that there will be a white paper that will come out early next year, and that will give the occasion for a consideration of what politicians may do in this. But there are other important players in the federal debate. Those other important players are called judges, and the judges of the courts of Australia who determine constitutional cases, but relevantly the justices of the High Court of Australia, have a very important role in determining what the delineation of power is between the federal and the state and territory legislatures. And the 100th anniversary of the engineers case will come up in 2020. And those who are looking at where it has led us should, I think, be preparing the way. Some brave counsel will rise in the High Court and cite the engineers case, and somebody on the bench will say, but that is nonsense. You have to give a contextual interpretation. We do that all the time in other construction cases. Why should we not do it with the Constitution? And then that counsel will say, sir, if you give me the opportunity, I will present a different and better argument on the morrow. And the High Court will permit that to happen, and that person will go on to become the longest-serving Prime Minister in Australia. So thank you very much for inviting me. This is a really excellent book. It's quite complex. There's a need for a simpler document for school children and for citizens, because a good point made in the book is nothing has ever been achieved in constitutional change in Australia from colonial times without engagement with the people. And therefore, it can't just be experts, and it certainly can't just be economists or lawyers. And it's necessary for us to find a way to express these ideas simply and persuasively so that ordinary citizens can be engaged.